The Magneton rules created a very fundamental difference between legal insanity and medical insanity. The medical conception of insanity covers many more mental states than that is covered under legal conception of insanity. There are many conditions of mind which are classified as medical insanity or medical unsoundness under medical law. But for the law regarding insanity to take effect, all kinds of medical conditions are not admissible. A medical condition is relevant to law only if it precludes a man from knowing the nature of the act or from knowing that what he is doing is wrong. Suppose a man is suffering from a particular medical condition, but it has not impaired his knowledge that what he is doing or his knowledge of the fact that what he is doing to be wrong, then the protection of legal insanity is no longer afforded to that person. The law is not concerned with the medical condition of a man. It is only concerned with a particular sphere of mental defect which has affected the ability of a man to know the nature of his acts. The Indian law on insanity is covered under section 84 of the Indian Penal Code. It proclaims that nothing is an offence which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law. It is important to note that prior to the formulation of section 84, draft section 66 and draft section 67 for the Indian Penal Code carried a very different meaning and carried a very different ambit regarding the law on insanity in India. Draft section 66 provided that nothing is an offence which is done by a person in a state of idiocy. Draft section 67 provided that nothing is an offence which is done by a person in consequence of being mad or delirious at the time of doing it. As should be evident, the scope of these draft sections was much wider and larger than the Magneton rules. For example, under draft section 67, the scope of immunity granted to a mad person is not confined to any particular effect that the madness might have had on him. Instead, it extends to all the possible influences of madness. If the act was in consequence of his madness, even though he was acutely aware about what he was doing, he would have been protected under draft section 67. Similarly, the ambit covered by draft section 66 is also very expansive, as it excuses a person from criminal liability for his acts if it is done in a state of idiocy. Whether the act in question was prompted by idiocy or not will not be that relevant. It has to be noted that draft section 66 and 67 were formulated before the formulation of the Magneton rules. After the Magneton rules were proclaimed in England, to make the Indian law in conformity with the Magneton rules, section 84 was formulated, was made in line with the Magneton rules. When we analyze section 84, we see that in order to claim the protection of section 84, a person has to claim three ingredients to have been satisfied. First, that at the time of committing the offence, the accused was of unsound mind. Second, because of the unsoundness of mind, he was not capable of knowing the nature of the act at the time of committing the offence, or because of the unsoundness of mind, he was not capable of knowing that he was doing something either wrong or contrary to law at the time of committing the offence. We will deal with each ingredient one by one. Unsoundness of mind. It is important to note that unsoundness of mind only at the time of committing the offence matters, and not unsoundness of mind before the commission of the offence or after the commission of the offence. The person must have suffered from unsoundness of mind at the time of commission of the offence. The conduct of a man before the commission of the offence and after the commission of the offence can be relevant evidence in determining whether a person was indeed of unsound mind at the time of committing the offence. But if a person was of sound mind while committing the offence but became of unsound mind after committing the offence, section 84 will no longer be applicable. In the same way, if a person was of unsound mind before committing the offence, but he was of sound mind at the time of committing the offence, he will again not be given the protection of section 84. The term unsoundness of mind has not been statutorily defined. However, in terms of its general interpretation, it is equated with insanity. There is no definite cause, there is no definite groupings in relation to the type of insanity which will be covered under section 84. For the purpose of section 84, the only requirement is that a particular unsoundness of mind, no matter how it has been caused, has led the person incapable from knowing the nature of the act or from knowing that what he is doing is either wrong or contrary to law. The reason behind the unsoundness of mind is not relevant, and the only point of consideration is the effect that the unsoundness of mind has had on the person. Second ingredient is incapacity to know the nature of the act. Here it is important to place emphasis on the word know. Section 84 is applicable only when the unsoundness of mind affects the knowing of a person. That is, it affects his knowledge about the nature of the act. It affects his knowledge about what he is doing to be right or wrong or contrary to law. Suppose it did not affect his knowledge, only affected his emotional control. That is, because of his unsoundness of mind, he knew what he was doing to be contrary to law. But because of his unsoundness of mind, he could not control himself. He could not stop himself from doing it. The same is not covered under section 84. By nature of the act, what is implied is the physical and immediate consequence of the act. It is important here to quote Maini, who says that a man is properly said to be ignorant of the nature of the act when he is ignorant of the properties and operation of the external agencies which he brings into play. To illustrate what he means, it will be useful to cite an example used by Stephen to show how a man did not know the nature of what he was doing. That is, when a person severes the head of another sleeping person in order to enjoy the fun that he will have when the sleeping person wakes up and searches for his head. That is a clear case of the man not knowing what he was doing. He had no idea that cutting off the head of a man will kill him, and so he will never wake up to search for his head in the first place. Now we come to the term wrong or contrary to law. The meaning of the term in England has at times been authoritatively held that it does not mean legal wrong. It means legal wrong and not moral wrong. That is, the term wrong refers to the fact that something which is legally wrong and not something which is morally wrong. So the incapacity of mind, if it has affected the knowledge of a person about the awareness about whether something is legally wrong or not, only then the concept of legal insanity will be applicable. But when we look at section 84, we see that there is a clear mention of the term contrary to law. That is, the term wrong and the term contrary to law both have been used in the same section. So it is more logical to assume that the term wrong as it appears in section 84 does not mean legal wrong, because that particular idea is already covered by the phrase contrary to law. But it may be noted that this particular debate is primarily academic, because it does not have much practical utility, because the distinction between legal wrong and moral wrong does not as such determine the fate of a case, and it is primarily an academic concern. One thing which has to be noted here is that if a person did not know what he was doing to be wrong, he would not be criminally liable even if he knew the nature of the act. It also needs to be appreciated that the phrase wrong and the phrase contrary to law can only be applied alternatively. That is, if a person was aware that what he was doing was wrong, but was not aware that what he was doing was contrary to law, he will be liable. If a person was aware that he was doing was contrary to law, but what he was doing was not wrong, he will still be held criminally liable.